directly pertinent to our discussion this evening, Mike has been a member of West Michigan Branch Board of the American Civil Liberties Union for 28 years. He's former board chair. He's an active member of the Branch Lawyers Committee. He assisted in ACLU litigation, including recently Turvey versus City of Wyoming, involving medical marijuana, City of Kentworth versus Speak, that's panhandling and election monitoring. He is a frequent speaker on civil liberties and consumer law, and he was the recipient of the 2013 Civil Libertarian of the Year Award from the West Michigan branch of the ACLU.
Yeah.
Thank you.
Excuse me just a minute. He would like to record the session. Is that all right with you? I mean...
Yeah, I think so. Everybody has been sure to sign in because I've been asked to provide a copy of that to the local FBI office. Just to kind of keep track of what's going on.
He is
And
not
I'm sure they'll want a copy of the video also.
Did you refuse when they asked?
No, you can't do that. I used to talk about privacy back in 2001 when we just had the USA Patriot Act, and I know there's been a kind of a resurgence of interest, and I think it's kind of interesting. What I would like to talk about is, first of all, what do we mean by privacy? What do we want to mean by privacy? Why do we need it? And then some of the legal development of the law in this area, and then some of the things that are happening today and some of the peculiar threats to privacy that we have. What we mean by privacy is not all that clear. And I've tried to figure out what I think it means from some court cases and others. And one of the best things I can come up with is the right to be let alone. This comes from a famous court case. Actually, this was a dissent. This did not turn today in the Olmsted case. But this is what Justice Brandeis, who is one of the famous writers about privacy, has said it means. And then, kind of on a less academic plane, I always thought that one of my favorite movies here, that never won any Oscars, obviously, but we want to be free to ride our machines without being hassled by the man. I thought that was a pretty good statement of what we want by privacy. The obvious question that maybe we could discuss a little bit at the end is why we need privacy. You hear quite often, not only we have to trade in some privacy for some safety, but why do we need it? If you're not doing anything wrong, why do you care that somebody, the government or somebody else knows everything you do? And I can kind of defer that question till later. This is an old English case, as you can see, from the 18th century, and it kind of pops up in a number of court cases in the United States from time to time, and it talks about where our legal idea of privacy came from. And as you can see here, I hope you can read that, that's clear enough, it has a lot to do with property. That was kind of what the English court system and then later on the American court system initially thought of what we mean by privacy, which meant, as a practical matter, that the more property you own, the more privacy that you're entitled to. And it dealt with your home property that you own. The basis for privacy in American law primarily is the Fourth Amendment, which perhaps protects against unreasonable searches and seizures. And again, focuses quite largely on certain areas of property, particularly one's home. Olmsted was an early wiretapping case. And the way this came out is wiretapping is not a violation of privacy. The court said, the majority of the court said, it is not a violation of the Fourth Amendment because nobody invaded the house. The wiretappers were outside the house. They were just listening in on the telephone line. And the idea that well, if you project your voice outside your house over a telephone line, you're kind of giving up your idea of an expectation of privacy. And there was no seizure of the person. So that case said wiretapping does not violate the Fourth Amendment. Now, there's been some development. Katz was a later case, 1967, that involved a telephone booth. What the police did there is they didn't actually tap the phone line. What they did was they had a device which could pick up the vibrations coming off the telephone booth, the glass, so that you could actually hear one side of the conversation. And that went up to the Supreme Court with the argument that that was a violation of the Fourth Amendment, that it was an unreasonable search. In that case, the court went the other way. It actually adopted Justice Brandeis' dissent from the Olmsted case and set up what has kind of become the modern test for unreasonable searches and seizures. And that's a two-part test, which is now not quite so dependent on the physical location. And that is, first, that there is an expectation of privacy, and secondly, that it is a reasonable expectation of privacy. And in that case, the court held that there was a reasonable expectation that the police are not picking up the conversation by monitoring the vibration coming off of the telephone booth. That was a kind of a close call, because the other argument was, well, what could be more public than a telephone booth? You can even see it. It has glass sides out in the open. But this is basically the test that we've been working with for quite some time. That comes up in a number of ways, and you can see, this is a footnote that became important, a footnote to the Katz opinion, and that is whether safeguards other than prior authorization by a magistrate would satisfy the Fourth Amendment in a situation involving national security is a question not presented by this case. So Katz dealt with normal police surveillance dealing with crime. I think that this was a case involving alleged bootleg. A lot of the cases come out of Prohibition and then later on. Here we have a case involving, this is a fairly recent case, 2001, involving thermal imaging of a house. You've probably heard of this technique. It's used for people who are growing marijuana to find it. You thermally image the house and try to determine whether there's an inordinate amount of heat coming out from a part of the house, which then you presume must be a grow room. And then you use that to get a search warrant. And the basis for most of this is, kind of the general rule is, if there's a search, it requires a warrant. That the police have to go and make an application to a judge demonstrating why they need a warrant, why they're entitled to get a warrant, and saying that there's probable cause to believe that there is criminal activity involved. These cases there was no warrant. And the question was, is this the kind of search that violates the Fourth Amendment if it has no warrant? In this case, the court said yes. They talked about this is the kind of sense-enhancing technology that's not in the general use. It's not something that people normally expect to have happen. And that in a way, it's a kind of way of using technology to sort of enter a home, a private home, even though you're not physically doing so. So in that case, the court said, well, this is a search. You can't do this without getting a warrant. But we have another case later on having to do with low-flying planes flying over a backyard of a house that was protected from most visibility with a fence. And the question was, you're flying over, looking at it with a plane at 1,000 feet. Now, this is not a normal airliner at 1,000 feet. Not part of a routine patrol. Is that a search? Is it an intrusion that one would not expect? And the court said, no, that's okay. There's nothing private about the airspace, and this is going to become, I suspect, another issue when we're talking about things like drones, which can be used not only by the government, but they're becoming apparently fairly available to private enterprise for various reasons. So what if there's a drone flying at 30 feet over your backyard? I think that's going to come up.
Shoot it down.
We had some shotgun remedy.
Okay, it may put a damper on nude sunbathing, as well as growing marijuana. Then we have a case, very recently, where the government actually, the police installed a GPS device underneath someone's car, so that they could monitor wherever that person went with GPS. And in that case, the court said that was going too far. Even Justice Scalia, writing the majority of the opinion, said that's a search. But that is, there was an angle to that case, and that was the fact the court thought it was significant that the police actually inserted this device onto a private vehicle. So getting back to kind of the property angle of privacy, that was significant. The fact that they invaded in some way one's private automobile and attached that device.
And surreptitiously, without the knowledge.
Oh, absolutely.
Of the owner.
Yes. And now I want to get to Griswold. Griswold, most of you have heard of. That's the case involving birth control. It struck down the anti-birth control law in Connecticut. And why this case is important, it's basically the seminal case for a kind of an abstract right of privacy. Not entirely, not just connected, this case obviously didn't involve a search, it didn't involve a seizure. But for about the first time, although it did kind of reference some earlier cases, the court said that there is a zone, each person has a kind of a zone of privacy, that some things are just beyond government involvement. And this case is much criticized. This is actually the basis, you may know, for the Roe versus Wade case having to do with abortion. That there's a lot of criticism that the court kind of constructed a new right that isn't expressly in the Constitution. And even though that argument has not prevailed in a lot of cases, it's still good law. And I think most people agree with the idea that there are some things, at least, we can disagree on what things, but there are some things that are private. Often, legally, it has to do with the family, with marriage, that just are no business of the government. Whoops. Let me get back to here.
Nice lighthouse.
I think that was just came with the computer, actually. Now, what happened is a response to some of these cases, particularly the Katz case having to do with the telephone booth, is Congress stepped into the act. And they enacted the Electronic Communications Interception Act, and that generally tries to set out standards for police wiretap. And it usually requires a warrant before the police can tap the phone. But that has to do with the police. When we get to national security, or claims of national security, we're into a whole different ballgame. And this was a case, the Keith case, this had to do with a wiretap of some radicals. Actually, anybody that was in Ann Arbor going to school when I was in the late 60s could remember some of these people. John Sinclair, Pun Planandan was actually the principal defendant in this. He's now living in southwestern Michigan, I think, very involved in Native American activities. And this involved a wiretap. There was no warrant, but the government said, well, this is different because this was national security. What they were investigating here, Planandan was accused of being involved in the bombing of the CIA building in Ann Arbor. He was part of the White Panthers and some other radical groups that were quite well known at the time. And Judge Damon Keith, it's called Keith decision, who was in the federal court in Eastern District of Michigan at the time, ruled that didn't cut it. Even though this had to do with national security, that argument did not carry the day. There's still some privacy, some Fourth Amendment rights involved. That went up to the Supreme Court, which agreed, said, we conclude the government's concerns having to do with national security again do not justify, in this case, from the customary Fourth Amendment requirement, judicial approval. Judicial approval meaning you have to go to a judge with a request for a warrant and demonstrate probable cause. Now, in response, partly to that case and partly to, some people may recall the Church Commission, which exposed a lot of real abuses having to do with domestic surveillance. I mean, they were, you may remember hearing about surveillance of the Southern Christian Leadership Council. Dr. Martin Luther King was intensely surveilled. Every radical in the country under J. Edgar Hoover. And a lot of that came out in the Church Commission. Now that's where we get the Foreign Intelligence Surveillance Act of 1978. And unlike what we kind of think of about FISA now, initially that was thought to be a check on government surveillance under the domestic security or national security rubric. The idea was that the prior act, the Electronic Communications Act, was intended to cover normal police surveillance having to do with normal crimes. And we have a different set of rules governing national security. Congress thought we can't make them go through quite the same thing, so we'll make different rules. However, it was very limited. It applied only to foreign agents. It generally required a warrant, and it did create this special Foreign Intelligence Surveillance Court, the FISA Court, which we still have today. The FISA Court is made up of, I think there are 7 or maybe a couple more lately, federal judges around the country who are appointed by the Chief Justice of the U.S. Supreme Court. And they're charged with reviewing requests for warrants having to do with foreign intelligence, theoretically. And there was not a whole lot of complaint about that for quite some time until 2001, when within weeks after 9/11, we have this huge USA Patriot Act. Does everybody know now what the acronym stands for? The Department of Acronyms, I thought, should get some kind of special award for this one. Uniting and strengthening America by providing appropriate tools required to intercept and obstruct terrorism. You have to remember that. Now, among other things, the USA Patriot Act dramatically expanded FISA. It went from what was limited to, I think it was public transportation, to any activity. It allowed the government to obtain anything. And this is where you may have heard at the time there was a lot of complaints about that they could request records from a library about who's been reading what books. In response, to their credit, librarians typically, I think, have been quite free speech people. And a lot of libraries, I think, still do this. Deliberately do not even keep such records. Once you return the book, they intentionally do not keep any more records, so that if somebody from the FBI comes saying, we'd like your records of who's been reading what, they can legitimately say, we don't have any such records.
Excuse me. The most pernicious thing about that particular library thing was that the librarians are not allowed to disclose if there has been a request or how many requests have been or anything. I mean, it kind of shuts down any record of these searches being conducted.
It is a felony for any person, including a librarian, and we'll get to some other people later on, to whom a request has been made to reveal that such request has been made. This came up later on. The ACLU, on behalf of Amnesty International and some other groups, tried to challenge some surveillance of foreign emails and phone calls and stuff, and they lost. They're pretty sure that some of these groups, like Amnesty International and some others, were being surveilled. But they couldn't prove it because of what you just said. All the requests, the warrants, those were all secret. Government will not say, and therefore the courts held that none of these groups have standing to challenge the practice because they can't prove that it happened to them, and legally they can't find out. Trap and trace, that has to do with the origin and destination of communications. That's been since expanded even further. Maybe not the like telephone calls. Who are you calling? When are you calling? So that dramatically expanded what the government could, under the law, do. What we're at now, this kind of gets us up, I think, with skipping a lot of important things, but to the present. And what we're starting to hear now from Edward Snowden, et cetera, those things, I think the big issue now that we're dealing with is technology. Up until recently, the amount of spying that the government or anybody else could do was somewhat limited because there are a limited number of spies. You can't tap everybody's phone because we don't have enough phone tappers to do that. But given the enormous computing power, and I didn't think I was all that illiterate when it came to computers, but I've been amazed at what they can do. And this is the new NSA, National Security.
That's
Fort Meade.
It is.
Yeah,
that's the HQ in Maryland.
That's Maryland.
Well, then the caption that I got off the internet is wrong.
Yeah, this one says Fort Meade, Maryland.
Okay.
Same picture.
But there is a new NSA computer center in Utah, which has just recently gone into operation, and I think it is the biggest computing center that there is anywhere. I think it's bigger than Google and some of the other big players. So what they're able to do is intercept almost all internet traffic. You know, you used to think, well, what good would that do you? How could you possibly filter through, have time to read or look through all the internet traffic? Well, apparently there are computer programs that are good enough that you can, with, I don't know how accurately, but you can filter and try to sort out some of the needles in that enormous amount of hay. So that's going on. This is basically, this, by the way, is a report from no less an authority than the Wall Street Journal. It didn't come from Mother Jones or The Nation. Yeah, you can't see, it's hard to read anyway. This is a diagram of how the NSA intercepts and tries to filter internet traffic. PRISM is a program, this is a software program used by the NSA. It's very public now, to try to sort through all this huge volume of internet traffic. How you can collect it, it's directly from the servers of, among others, Microsoft, Yahoo, Google, Facebook, Paltalk, AOL, Skype, YouTube, Apple. Anybody use any of those? That's a lot of traffic. The justification, you probably heard, is, well, we collect all this stuff, but we don't necessarily look at it until there's some reason to do so.
Yeah, it's probably a good idea to describe what upstream is as well, which is a different program. What they do
Go
is
ahead.
they splice off the fiber and all the major hubs where different telecom providers, especially if they're going to do overseas traffic, but essentially it's all domestic traffic as well. Wherever the telecom providers have fiber and connect to one another, they splice off the fiber and just suck up the fire hose. Just all the traffic just goes right into a database.
Yeah, who is it? I'm trying to remember the big provider. Am I thinking of who actually, they've actually constructed a line
Right. Well,
directly?
It was
Was
the
it
Electronic Electronic Frontier Foundation
Yeah.
that originally had a whistleblower provide an affidavit. This is what led to all the warrantless wiretap cases that they were litigating. But they actually had somebody who had seen the work that NSA was doing at the AT&T hub in San Francisco and said they're doing this all over the country.
I remember that.
They did that with AT&T, right?
They did it at AT&T, Verizon. It was both a crime and a statutory tort for each of those telecom providers to allow that to happen. It was a violation of the FISA Act at the time that this was happening. Congress retroactively passed immunity because if the EFF had won their cases, their plaintiffs would literally have owned all of the telecom companies in the United States. The damages they faced were that big because of the massive level of the wiretaps.
Well, there's some real problems, though, with the lawsuits, which I think are unfortunate. One is there is a doctrine that a lot of courts have applied, which says that once the government says this is a matter of national security, hands off, courts have been in the habit of simply dismissing lawsuits without any particular showing. You'd think that the judge might ask, well, explain to me why this is a matter of national security. Well, I can't do that because it's secret. X key score. That is another program that allows searching of emails, online chats, browsing history. According to Snowden, and there's a lot of controversy about whether what he did was right, but not a whole lot of controversy about whether he's accurate. And a lot of the documents are publicly available now. You have to keep up on this. I think you probably need a subscription to The Guardian because things change every day. But he claims that he can sit at his desk and if he has your email, he can do real-time monitoring of what you're doing on the internet. Yeah, this is Verizon. Verizon, of course, is not unique. But this order actually is, this is a quote from the order, and I looked at the order, it's publicly available, from the FISA court. Rarely, for some reason, but very rarely, those kinds of things get revealed. I don't know whether this came from, I forgot exactly how this got out in the public. But it requires Verizon, on an ongoing daily basis, to give the NSA information on all telephone calls in its system. And I kept rereading the order thinking there's going to be more. It's going to say all telephone calls which have to do with, but no, that's it. All telephone calls in its system on a daily basis. Now that is, we're talking about metadata here. That is not probably the content of the phone call, but it's the metadata. It's who's making the phone call, who's receiving the phone call, how long does the phone call last, and probably the location of the sender or the receiver of the phone call. That's the metadata. We also know now that encryption, which I read for a while, I remember several years ago that the new mathematical systems of encryption were foolproof. Apparently that's not true for a couple of reasons.
The math that's properly implemented is still good.
One of the problems, of course, is that the makers, the NSA, has convinced the people involved in encrypting and decrypting to give them a backdoor. There was...
It's only proprietary software, though. So if you use GPG, for example, you've got a lot of eyeballs looking at the code to make sure that the code implements the math correctly. So there are implementations that are still good and
There are some
can't do. But a lot of proprietary software can be broken because they deliberately make the implementation of the math flawed.
And apparently this happened with a lot of the big producers of the software.
Right.
Well, it's that felony thing. Hi, I want you to be I'm from the government, I want you to be my ally. Once I make you my ally, by the way, it'll be a felony for you to tell anybody about it. Now I've got you hooked. It's the Faustian bargain with the devil.
Yeah, there are apparently two ways that they do it. Some is voluntarily. I mean, a lot of this stuff, I believe, these big companies just voluntarily comply. And some is maybe involuntary, with an order that you have to give us this stuff.
They also compromise personnel at some of the big tech companies too. They have essentially U.S. government agents who were simultaneously working for the companies don't even know it. So there's a covert op going on.
Which makes you think that if the government, U.S. government can compromise some of these people, maybe somebody else can too.
Right.
But that's, I guess I'll have to, my John le Carre books are getting kind of obsolete, and have to get to something a lot more technical, the spy of the modern age. This is kind of distressing as more and more computer activity, more and more data is being stored in the cloud, as it were, on some server in some big company. That's becoming more available. And Microsoft seems to be working pretty closely with the NSA and the FBI to give them access to all that stuff. Skype, by the way, Skype calls, I think, unlike other telephone calls, we're talking about getting the content, not just the metadata. The other thing is, this last thing, material collected through PRISM is routinely shared with the FBI and the CIA. The team sport, they call it. Now, there was a case out of the FISA court some years ago, which somehow got, the FISA appellate court, which got revealed, called in-race sealed opinion. And the issue there was, how theoretically this is supposed to be foreign intelligence stuff. How far away can you get from foreign intelligence? Well, the court ruled that foreign intelligence does not even have to be the primary purpose of the warrant, of the search. So long as there's something to do with FISA, even though the primary purpose may be regular law enforcement. In fact, during the Clinton administration, I guess this was not a law, this was an executive policy. The policy was that somebody from the intelligence, the foreign intelligence division of the FBI or the Justice Department had to go with the assistant U.S. attorney who was requesting the FISA warrant. They called that the chaperone rule. You have to be chaperoned by somebody having to do with intelligence, foreign intelligence. That got eliminated. So now we have normal law enforcement personnel using the FISA court to circumvent the normal warrant procedure in the course of regular law enforcement. This is a photograph of tracking devices. Anybody have one of those?
They're cell phones, aren't they, the cell phones?
Yeah, they do that also. This is from a case, actually, that showing what the government was able to get. And your cell phone, of course, tracks, everybody should know, where you are. Every time, even if you're not making a telephone call, it is constantly communicating with cell towers, and your cell phone provider has a record of when and where it is communicating with your cell phone. So that tells you where your cell phone is. So if you want to have a truly private conversation, you should do so in the woods, away from cameras, and leave your cell phone at home, or at least take the battery out.
When the two brothers in the Boston Marathon bombing, it wasn't long before the papers reporting that they knew that who they talked to their parents and how long they talked and to friends in there. Would that have been done on this basis, or would it have been on the previous one where you said they could intercept it or they could bring up records?
I remember, does anybody remember, I know the answer to that. I do remember hearing that, but I don't remember what system
Well,
picked that up.
they knew everybody that they had called to their, what was the country they were from?
Yeah, there's-
Yeah, I knew that. Now, would that
Or
have to,
Chechnya or something.
that wouldn't have to be a warrant, that could come in under the terrorism?
Oh, that information is definitely collected by the NSA
Yeah.
under FISA, yes, under the USA Patriot Act, it is. Almost all international communications like that, and they're particularly going to get it from countries like that. And, I'm sure that they're monitoring certain countries more heavily than others.
I know that sometimes on my iPod it comes up and says, will you allow us to use your location?
That's yeah, there are two ways that your cell phone tells where you are. One of them is what I was talking about. It communicates constantly with the cell towers. The second way is what you're talking about, and that's the GPS, global positioning satellites. So I think what it's asking you there is, do you want to turn on GPS, which will actually give even a more accurate fix on your location. So you can turn that off, but you cannot use yourself, you cannot turn off the tracking via cell towers.
Is there any kind of law, like, saying that they have to give you that option? Then they just turn
No.
GPS? No. There
No.
isn't any kind of protection, it's just got.
As a matter of fact, this is a case decided a month ago by the Fifth Circuit, in which the argument was made that they should not be able to. What they did was the government went to the provider and said, give us all of the information about where these people were at all times. And we're talking, again, about a map of everywhere that they went. In this case, they got 11,000 locations, an average of, I think that should be 173, it's cut off, per day. So it traces one's movement completely. The argument was made that that's a violation of the Fourth Amendment. Yeah.
Are you saying that all cell phones are, as long as the battery is up, is transmitting?
Right.
Yes.
Is that, now, why,
Or could
the
be.
companies?
Well, no,
Have the companies, has the government told the companies that produce these that they have to do that?
That became mandatory for all cell phone models, I think it was 5 or 6 years ago. There was a point in time at which all cell phones produced henceforward had to have that feature.
Okay, that was a federal law?
Yeah.
Well,
Is it? And that,
the cell system has to know where the cell phone is, because if I make a cell call to your cell phone, it has to be somehow routed to the cell tower, which is close to your cell phone. So the system will track your phone.
Even if it's turned off?
I think it's, yes.
I heard
Yes.
if it was turned off, it still tracks it.
I think so.
Yeah,
I think you have to take the battery out, right?
It doesn't have to, but apparently I don't know if they did it through, they've got a huge hacking program as well. I don't know if they did it through that or whether it was mandated for the cell phone companies to put it into the product, but apparently even a cell phone that's turned off, they can activate the mics and get information. I have no idea how that works. That's way beyond even my knowledge, but at least some of these reports, including the Snowden stuff, confirms that they do have these capabilities.
Well, you know, I used to have I'm not a computer expert or anything, but I used to have a program on my cell phone, I may still do, I don't know, to find a lost phone. I don't know if everybody's got one of those. You say like, find my droid, and it will make the phone ring even if it's off. So apparently, cell phones can be remotely activated even if they're off.
So in other words, in reality, if we call 911, they should be able to tell right where we're at.
Exactly. That's another reason for it. I mean, that's a valid reason. Yep.
Is that, I don't think our local enforcement is up to date on that, because I don't think they have the capability, or they don't know how to implement that.
Well, I don't know whether like the local police department is up to date on that, but yes, that capability is there for that purpose.
Yeah, it was built into the network back in the mid-90s. That was the government requirement, it's part of the COAN.
So in other
That's
words,
the cooperation with law enforcement. Yeah.
That's how the camel got its nose under the tent. Before we had cell phones, 911 didn't need to know where we were at unless we told them. I still don't need 911 to know where I'm at unless I tell them.
Well, the theory is that, you know, you may be in an emergency. A lot of times people aren't very good at giving, like in an auto accident, are not very good at giving their location. So I think there can be legitimate.
At the moment of a violent assault and you call 911 and the operator says, tell me your address, and you're being stabbed or shot or beaten, you've got time to recite your address, you know. There's some legitimate situations where I would like.
Well, let's keep ourselves on track here with Mike.
Yeah, there are a few, I think, really problematic ideas in this decision. Number one, we know that the Fourth Amendment only applies to the government. It has nothing to do with Verizon or Microsoft or AT&T or Google. So anything that you give, and I think this, we may need some more, we do need some more laws here. But anything that any information that's picked up by any of these companies is not protected by the Fourth Amendment. Secondly, this idea, and this is a problem I think in some other areas, that you have voluntarily conveyed this information because you voluntarily had a cell phone. Well, I personally think that stretches the idea of voluntary. And I think that what the law does not recognize, and really should, there are certain things which, although they're maybe not necessities of life, have become very difficult to go on without. I mean, this was used at one time for telephones. Well, you don't need a telephone. So why should you necessarily expect privacy on your telephone calls? This argument is made, for instance, in one of the areas I do, which is consumer law. One of our big problems is mandatory binding arbitration clauses, which prevent you from suing somebody, like your cell provider or your bank or a number of other businesses. Well, those are voluntary. But the problem is, every cell phone provider requires that you sign, even though you don't know it probably, but that you agree to a mandatory binding arbitration clause in order to have a cell phone. And I think that we're getting close to the time when a cell phone is becoming something sort of akin to a necessity for a lot of people. Or a bank, for that matter. Yeah, you don't need to deal with a bank. You can keep all your money in cash, sort of. But it's one of those things that is becoming close to a necessity. And then the other problem here, the third problem, I think, is, well, the government did not get any information from the target. All they did was request or demand information from the cell phone provider. So the court said the target of this doesn't even have standing to object. They're not being searched. It's only Verizon or whoever is being asked to hand over data. Well, you know, this is kind of circular. That means that everything that's picked up by Verizon, Google, any of these companies that you deal with, which themselves amass enormous amounts of data, then is fair game for the government because they're not invading your privacy. A couple of other things to, if you're not paranoid enough. Cameras, license plate trackers. These things are becoming very, very common. In fact, there are federal programs to fund local police departments to install these on both in squad cars and in street corners and all over the place. And they are apparently good enough to instantly read and record license plates. Now, we're dealing with this a little bit with the ACLU in Grand Rapids. And the question is this: we don't particularly agree to object to the idea that the police ought to be able to spot a license plate and run it to see if it's a stolen car or if it's somebody for whom there's a warrant. The problem is what's done with that data. We do object to the police keeping it for a long period of time, like a year or two, because what you can then do is you can build up a database and basically know where somebody's been. Again, this is a tracking method. If you have enough data points, if you have enough cameras and a computer system that can then tie these things together, you can track and see where somebody's gone at any time during the past however long you keep the data. That's about all I have to say about the government. The government, of course, is not the only person who is threatening our privacy. A couple of other things. Internet privacy is if there is such a thing, I don't know. There are a lot of proposals, a lot of legislative arguments. There's not a whole lot of law yet, but there's a lot of issues coming up. Social media, I think everybody knows that anything you put in Facebook or LinkedIn or something is fair game, right? I think I might even agree with the idea that there's no reasonable expectation of privacy if you post somebody on your Facebook page. Nevertheless, it is amazing what some people will put on their Facebook page, apparently on the misguided notion that this is just going to be looked at by your friends. Lawyers routinely will search Facebook for opposing parties, witnesses, opposing counsel to see what might be up there. You can often find some real interesting stuff that you wouldn't think people would put out there. Search engine, internet browsing search engines. You all know that wherever you go on the internet is tracked, right? I mean, it's not a coincidence that if you were looking at, went to someplace to look at table saws, you're then inundated with ads for table saws. Now, theoretically, that's not supposed to identify you. It's supposed to identify a number, which then the Google and people like that can use to bring you ads. But they don't really know who belongs to that number. A lot of people who know a lot more about the internet than I do have a lot of doubt about that. E-commerce is a big thing. People buy stuff on the internet with their credit cards. This, I think, maybe has a little more paranoia about it than there needs to be. I personally would not, you have to be careful, of course, but you should know that you're not going to be liable for stuff that other people charge on your credit card if they somehow get a hold of it through the internet or whatever. If you read your credit card statements and promptly object to charges that are not yours, you're not liable for that stuff. So you do have some protection against liability from some of these things.
Okay, but Mike, let's say that a company called Axiom, A-X-C-I-O-M, I believe, collects from your credit card company and all the credit card companies what your buying habits are, puts that in a database along with cross-references about what your zip code is, a lot of information about demographics.
Yep.
And your browsing history cross-references that with ads that you've clicked on from Google, and then sells that to the NSA. And that winds up in Bluffdale. Do you like that?
Well, you're assuming that the NSA has to pay them for that. And not just ask for it. Yeah, all those databases that are privately collected certainly
I mean, the NSA does pay pretty well for this stuff.
Yeah.
But I mean, even Poindexter was trying to sell total information awareness. One of the big points in that was, yeah, we're gonna collect this all from Axiom and the credit card databases as well, and then cross-reference that with all the stuff that we do through normal methods of collection.
And as I recall, there was a great deal of opposition to TIA.
And that was that.
And Congress did not go along with it, but they went ahead and did it anyway, basically.
Pretty much, yeah.
Total information awareness. That was similar to what's going on now, that they publicized and said, we want to do this.
But people went nuts about it and thought
Yeah.
it was a horrible idea, and Congress thought it was a horrible idea.
Right.
And you're right, they went ahead and did it anyway, surreptitiously.
Yeah.
References to Poindexter, the boss of Oliver North from a couple of decades ago.
So, be careful with your computer, but any of the, there's all kinds of databases out there that people can buy. I even use one.
Today, NPR had an interview, I think it was, or maybe yesterday, on the Diane Reeves show of the reporter in the U.S. at the Washington Post who's been dealing with Snowden. And he said that he no longer does any of his reporting via computer at all because of the massive intrusive powers that are out there, and he wants to protect his sources.
Oh, sure, and computers could be subpoenaed or collected with a warrant. I mean, it's quite typical for the police or other agencies to say, give me your computer, I want your hard drive. And apparently it's very difficult to really erase things on a hard drive. People ought to know that. A lot of people don't realize that about email either. I tell some other lawyers, you kind of send these things quick or you reply quickly without thinking too much about it. Any email you send to opposing counsel, think of it as an exhibit that's going to get attached to a motion that goes to the judge at some point. So think about what you say. The other thing that people don't realize about emails is they don't go away. This is kind of a number of government officials who didn't recall that, particularly if you're using a computer that's on a network, like a government network or even a business network, these things are all backed up. So even if it's no longer on the PC that sits on somebody's desk, it's still in a server somewhere in a backup file, and that can be gotten at. And they typically are in civil litigation.
Well, maybe you wanted to get to that end of the, we have that.
That's about the end. Go ahead.
Well, so this is a more general thing. So my fear is that, say there's a couple of different providers of insurance that I can go to if I want some kind of like car insurance or something. And they can go on Facebook and find out they don't like my politics, or something like that. Or maybe I'm up in front of a judge for a speeding ticket and he's deciding whether to be, kind of lean my way or lean against, and he's got something totally having nothing to do with my driving. Those are the things that bother me. These things have a real potential to have a very significant effect on our lives.
Well, they do in fact check credit reports. You know that. Insurance companies check credit reports to determine whether they will insure you or how much they'll charge you. And they may deny you or charge you a premium if you have a bad credit rating, even though you're a good driver. It gets even more scary than that. We're kind of getting to the point with DNA where that kind of data is going to be not necessarily available. I mean, presumably there'll be some attempt to protect it, but it will exist. And what's to prevent your insurance company from saying, as a condition of getting your insurance, I want to see your DNA profile to determine whether you have a predisposition for some condition.
Or
Now-
we'll just take a cheap swab.
And run their own.
However, under the Affordable Care Act, you're not allowed to deny due to pre-existing conditions.
Yeah, that might be some protection.
That's the law.
It's an interesting thing to hear all of this, and then to interact with people who don't come to meetings like this, because they will say, so what? I'm doing nothing.
Mhm.
I mean, I'm just I'm just living, I just do what I do, I work, I take care of my family, I just, that's all I do. And what's to worry about? Because I am not worried that the government is looking in at what I'm doing. They can see everything if they want to, because it doesn't matter to me. So, in light of that, what's the message to John Q. Citizen out there that says, this isn't of interest to me because it doesn't affect me?
You could remind them that people in Germany in 1939, 1940 were saying something pretty much the same.
Yeah.
Well, that was my
Not that
initial
that would
question.
necessarily get through, but
Yeah, I mean, that's a point. If you're not doing anything wrong, why do you care if everybody knows where you've been going? If you haven't been visiting any brothels or speakeasies or,
Fair.
yeah.
Why aren't you coming out completely against the police license cameras? Wouldn't that be something that's like, okay, we know where this is gonna go. They've gotten by without them for years. They can fight crime just as well without them. Why have those? Why is it something where, what I envision happening is they're gonna fill up the jails with people with suspended licenses and these minor things that don't hurt anybody else. And then they're gonna go crying, we need a bigger jail. And it's not gonna be, the idea is, well, gee, we wanna see if somebody's got an open murder warrant on them or something. And it's like the camel under the snows under the tent. All of a sudden, if you let the thing get its nose under the tent, a few seconds later, you're gonna see the camel running down the road with your tent on its back. So if you don't stop this thing right now and just say, no, you don't need those cameras to go out there and do it. Grand Rapids isn't a hotbed of violent crime or any other type of crime. So no, we're not gonna use it. It's going overboard. You don't need to do it. The whole thing's a bad idea. Just scrap it. Why didn't somebody go get the ACLU? Why didn't you go get an injunction when they first came out with it? Stop it.
It seems to me that we walk around in the world all the time and we're surrounded by people who have totally opposing opinions on some things as us. And we just don't know it. And that little bubble of us not knowing that we disagree with each other on things is what allows us to be a democratic society. I don't know that you can be a democratic society if you don't have a little bit of space to change your mind, make up your mind, disagree with someone without having to distance yourself from it. You know, like in a workplace, you work with people who, if you knew everything about them, that would be a really hostile environment.
You might not want to know everything. I did some looking. Historically, though, there is some support, obviously, in the Fourth Amendment. I mean, that does embody, and some of the other Bill of Rights, the idea that we do want some privacy, at least the framers did. We don't want the government to know everything. And historically, of course, the founders, the framers, were not all acting under the assumption that nobody violates the law, or that you definitely ought to be caught. Puritans were outlaws. There was one crime that they habitually committed, and that was heresy, which was a crime in many of the colonies. A lot of the founders were smugglers. John Hancock was reputed to be a smuggler, in addition to being a legitimate importer. So these were not all people who assumed that everybody had to do proper things all the time.
I wonder if you could provide some insight on something that's been very puzzling to me. The NSA has had a program since at least the mid-1990s, and it probably goes back much earlier than that. That's when it was first reported, called Echelon. And it's a program that they operate in conjunction with the British government and the Australian government. There's a big monitoring station at Menwith Hill in Great Britain. There's one in Australia, and there are a couple in the US. And in the mid-1990s, the New York Times reported that they were monitoring every phone call, every fax transmission, and every email. And there was a very short period of time, a few days or maybe a week, where the New York Times and a few other outlets were reporting on that, and the story disappeared. Fast forward 20 years, almost 20 years, and along comes Edward Snowden, and it's basically the same story, but the media has just gone into a complete frenzy of 24/7 coverage. We have, more people using the computers now, and we have social media, which we sort of really didn't have in the mid-90s, but it's essentially the same story. And I'm just puzzled why there is so much media, such a frenzy over it now, whereas in the mid-90s, that was prior to 9/11, so you didn't have that excuse for this privacy violation. And yet the story was just dropped in 95, but now it's this, I'm just puzzled. I'm just curious if anybody has any thoughts on that.
I've got a couple of thoughts. First of all, Echelon is only if it's bouncing off of satellites, or was only if it's bouncing off of satellites. And yes, there was some SIGINT interception to the extent that we were using those microwave towers by some of our friends and then given back to NSA, but it wasn't actually as big in scope as this. And it was actually covered for quite a while, even back in the 90s. But yeah, Echelon itself was, I think the big story there was that New Zealand, Australia, Great Britain, Canada, and the United States were cooperating in such a way that if they had a rule like the United States has had for a long time saying you can't spy domestically, all five had found a way to backdoor around it.
Of course, Snowden, came out with a lot of stuff
Right.
in a very short period of time. He was close to a reporter for a major newspaper who published it all in a very short period. And he had documents. I mean, he's got proof of all this stuff.
Right, and it's still coming out too.
Oh, yeah. Yeah, I heard an interview with Greenwald after they held up his partner at the airport in England. And he was asked, is there anything more going to come out? He says, a lot more is going to come out. That's great.
Yeah, have you seen Quadris's, like just a short video on Edward Binney?
No.
Now, this is before XKeyscore, which is the database program that Snowden said he was able to query. The predecessor to that was called Stellar Wind. Edward Binney is another NSA whistleblower who did a video interview with Quadris. It was featured in the New York Times saying, hey, here's the Stellar Wind program, the program that I developed to help spy on Russians and to query a database on stuff that we were accumulating on Russians. They've turned that around and they're pointing it at the United States. That should have been a huge story at the time. It's now a much bigger story now that Snowden's confirming. But it's Binney that wrote the code, and you said that you had questions about how are they so sophisticated? They're able to pull all this stuff together. Binney's the guy who knows how they pull it all together. And he also became a whistleblower.
I think that we have to keep in mind a very important point you made, which is there is a right of privacy that's protected by the Fourth Amendment and some other bits and pieces in the Constitution.
Mm-hmm.
That applies only to government action. There's this whole mass of our economy with insurance companies and others gathering information and using it against us, invading our privacy. And we don't have protection for that. And I think that, again, I mean, our Republican administration, as far as I can tell, I mean, I'm referring to the Congress, where the House is so dominant, doesn't seem to be too inclined to do anything about that because it limits business opportunity, et cetera. But that's something I think we should all be paying attention to, is this great potential. We think of the enemy of the state, the government, the spy satellites and all that. That's great. But what about AIG or, Jackson National Life and DNA?
No, I personally agree that a lot of the constitutional rights ought to apply to at least big business and not just to the government. I don't know if those kinds of institutions of that magnitude were around in the late 18th century. But, you know, when you think of the First Amendment, all right, we don't allow the government to censor very much. But if the television networks decide that something doesn't get broadcast, that's censorship. I was concerned remember when the credit card companies decided that they were not going to transmit donations to WikiLeaks. All right, here we have a banking system that is cutting off commerce with certain entities that they don't approve of. So, yeah, I mean, there's a lot of threats. I believe that I wouldn't win that argument in court, but as a practical matter, you're right.
It just seems like this is all about, who was it? Chomsky wrote the book Manufacturing Consent. All of this is an effort, it seems to me, to force or engineer consent, because dissent is what is being tracked. Dissent is what causes the lights to go on. I think, for instance, I have a closing statement, a little salutation on an email that's a quote by Voltaire, and that talks about Edward Snowden, et cetera, et cetera. Now, I send that out just routinely. I attach it as a closing thing to anything I send out. Well, reasonably, I should know that that is to be tagged and flagged, and a conclusion brings us back to 1935. It brings us back to all the fascist kinds of things that are now laying out there for all of us to be looked at if we dissent. If we dissent. That's what this seems to be mostly about, the capacity to do that. And I mean, not just the capacity, the doing of it. How do we know what they're targeting and looking at? If we say that thing, they'll pick up everything else. I mean, that's where it goes.
Well, you're talking about picking up, for instance, communications, whether it's a telephone call or an email.
Exactly.
Several jumps from that. In other words, if I'm communicating with somebody from Al-Qaeda, or somebody in Yemen they think is, then it's not only going to target me, it's going to target everybody that I send to and everybody that they send to. So it expands.
There was a time when some of us had our names on an FBI file.
Yeah, I know. I remember people demanding their Red Squad files from the state police.
Right.
I was always too worried to do that because I was afraid that they would not have a file on it.
But isn't this just a parallel to it?
Howard, would you look to the ACLU to, I mean, so if we wanted to fight this, if we wanted to do something about it, is this something the ACLU's looking to take up?
Yeah, the ACLU has a number of, has litigated, and this is an ACLU case that I just talked about, that circuit case. Or
I wrote a letter to the ACLU because my husband died almost 8 years ago, and I have been having such trouble with listening into my phone calls, crawling around my house, going in my garage, I think putting the GPS on my car, whatever, and I contacted the ACLU, and they wrote me a letter and said they couldn't do anything.
I don't know about that one. You got to remember, the ACLU is
They
not.
said I had to have a lawsuit.
On a larger scale.
It is not primarily a service organization that can deal with individual problems, unless we think that this is something that we can deal with on a larger scale.
They had the Census Bureau come to my house to try to get my personal financial information in 2006. The census isn't even due until 2010.
But is there something that, rather than taking one individual's case, well, like you've done some class actions, you know, is that the way, do you have a sense of so we talk about this, and the more we uncover, the scarier it gets, and then like, well, so what do we do?
Well, there are two ways. There's two ways to do this. One is judicial, and the other way, which may be more effective, is legislative. Now, I mean, those are the two things we can do.
That's pretty bad when you say legislative is more.
Well, I know, they don't necessarily.
There was a question about what do you do about stuff other than government? I came in a little bit late. I don't know, you might have covered this already. Did we touch on the Warren and Brandeis article?
The case.
Well, Warren and Brandeis was probably the most influential law review article ever written.
Yeah, actually.
It's about the common law evolution of the right of privacy.
Yeah.
Aside from the constitutional issue of the right of privacy, Dan Solo right now at GW University is talking about sort of reviving a common law evolution of being able to sue about privacy issues against private companies.
Yeah, you're talking about the Harvard Law Review.
Right.
Back in
1890, yeah.
Was that when it was? I don't remember the date, but it was before Brandeis was on this. He may have been a judge. It was before he was on the Supreme Court.
Back when he was a law professor.
And yeah, that's out there. I actually have a copy of it on my jump drive. And it had a lot of the thoughts that later became his dissent in Olmsted, and then the majority opinion in Katz. This whole idea of a right to privacy, a kind of an abstract, yeah.
Do you have more in your presentation to present, or are we in question and answer?
You're in question and answer. We're yeah. So go ahead.
No, that's all.
Oh.
Just a quick note, when I was at Michigan State, I took a criminal law class that was taught by Sultan Ferenczi, and most people in this room probably know who he is.
Oh, yeah.
And he finally requested his Red Squad file when the time came. And the funny thing was, they didn't have one on him, but they had one on his wife, probably because she associated with him. But that was his comment. He thought it was quite a thing that they didn't seem to have one on him. But they target dissenters. And
Yeah.
I used to live in the People's Republic of Roosevelt Park, where one of our guests here tonight is a councilman. And I have a tendency to fight City Hall. So I also had a tendency to have an unlicensed vehicle in my driveway, and they just wouldn't leave me alone because of it. And they ended up towing it. So what my friend and I did was we took a video camera, we went down every street in Roosevelt Park, a 1 square mile city. We taped 20 other cars that were either unlicensed or sitting up on jacks in the state of not drivable. And it's like, none of them were being targeted, but I was. So the idea behind this is they want all this information, so if you, that's right, you sitting in the front row over there, wants to get up and raise hell about the government doing something, there's going to be a knock at your door. And it's going to be like, we don't want, the hint is going to be, we don't want you to do that. And my response is going to be, I'm going to continue to do that, and instead of you, now that you're at my door, I want to know where your personal residence is. And that's how you got to do it. You got to keep standing up to them, not threatening, just in a real calm tone of voice, calm, friendly tone of voice, and just stand right back up to them.
One of the controversies now is people videotaping the police.
Right, exactly.
Which they don't like at all, and there have been people arrested for doing it on the grounds that that's interference. You know, I want to say though that I do not say, and I do not think that this is Germany in the 1930s.
But it's getting there.
But well, no, and I'm not that pessimistic that I think we're imminently getting there. But I do think there are things out there to be concerned about, and that people ought to try to rein in.
Yeah.
I heard this wonderful story, and I think it's important to be able to laugh sometimes, that early on after the Patriot Act was signed, they were using the records of Blue Cross Blue Shield in Michigan to try to figure out who might be a terrorist or not. And they were doing a search of Lebanon and coming up with all the Lebanon streets in Michigan and all this irrelevant, information, because they just didn't know how to put together an intelligent search. And that whole search methodology thing of the content, once they decide something is worth looking into, I don't know how well developed it is, but it's kind of funny to laugh at that case at least.
Apparently they're getting better though.
I'd say so.
Yeah.
It's not for a laugh, it's more for the sense of irony. I'm sitting here thinking that I should become better acquainted with Justin Amash and others of his stripe, because they are very revolted by this phenomenon. And of all people, here I would want to, figuratively speaking, hold hands or, put my arms around Justin Amash and say, let's make cause together against this level of intrusion. As you say, politically, and I'm just, it's very hard for me to step through that little looking glass and be with Alice in Wonderland.
Can I call a conclusion to the matter for this evening and invite all of you to stay? Mike, well, I'm sure is willing to be around for a few minutes if people have further questions and comments for him.
Should we do a teaser about a month from now? Topic a month from now?
I'm coming to that.
Good.
Also announcements.
Oh, okay, I didn't know if there were any announcements. All right, well, we will, let me, if you don't mind, I'm going to begin by thanking Mike for coming from Grand Rapids, giving us very we really appreciate people making the effort to come over here and help Road to try to dig deeper into these issues that really trouble and concern us and that we'd like to work on, and it's difficult to know what to do. Next month, we are going to have a talk, and remember we are moving to the second Thursday, and this will be on October 10th. We will learn about implementation of the Affordable Care Act. You might recall that very early in our existence as an organization, we got a speaker, as I think the law was actually under debate or newly passed or some such thing. Now we see that it is really partly implemented and more going to be implemented and more people in our state will be covered and so forth. And we think it's time for us to learn more about that. And happily, we have right in our group someone who knows a great deal about that, and that's Margot Haynes.
But I may be able to get somebody even higher up to do it.
Okay, well, we will have a speaker, Margot or someone, so that will be next month. Several people came in late. Let me say what I did at the beginning, and that is we are recruiting people for the steering committee of Road. Please consider becoming a member of that group. Second, if you have areas of expertise and are willing to contribute and talk to this group, then we would like to hear from you, because we don't know what everybody else is an expert in. And feel free to write such things on our meeting evaluation forms, which are on the tables. So I will now, sorry?
And third,
What?
make my bucket overflow with money.
Well, yes, money in the bucket, money in the bucket. Margot, you had announcements.
This is a little bit off Road's typical topic, but I am offering a 6-week workshop starting the 24th of September on reproductive justice, which, as we saw here, touches issues of privacy in terms of, is my health and are my health decisions in the area of reproduction my right or other people's business. But reproductive justice looks at it more in a societal way. And if you're interested in this, talk to me individually.
I have a question.
Yes.
Okay, yeah, I came in late, and then I heard somebody mention money bucket or something like that. What is the cash box over there for? Donations for something or other? Is that
For this organization, so that we have money to do what we
Dan,
do.
you got two things confused. Plastic bucket for Road, metal cash box belongs to the community center here.
Oh, I
That's
didn't
where
even
they
see
take
that.
money for coffee and rent.
Oh.
Plastic bucket is the one that's about
Yes,
Road.
with our, and there's a petition on the table. If you haven't signed against fracking, you may sign that petition. We welcome that. Be sure you sign in the right county, and if your county isn't there, there are blanks. Flip the page, fill in your county name, and sign away. The other thing is you are more than welcome to sign. If you are opposed to Walmart, we have petitions to oppose the locating of a Walmart supercenter in Whitehall Township. So I thank you all for coming. We have a little bit of coffee left here, some wonderful cookies from Hildy Paulson.
evaluation, I really appreciate it. Thank you, my friend. Great help.
No, I was thinking of there were some of those little wonders, yes, I would have
You know why?
Good.
I don't have a cell phone. You don't know how to work there.
And I haven't, you know, I haven't worked in I wasn't.
I know, and I love sitting here, I haven't missed a Scott. I'm Van Hoven, Dr. Van Hoven. It's been you, I appreciate the insight. You've been following it closely.
I emailed her yesterday.